This hearing of the Committee on the Judiciary, Subcommittee on Commercial Administrative Law will now come to order. Without objection, the Chair will be authorized to declare a recess of the hearing. I will now recognize myself for a short statement. With our hearings today and tomorrow, we will continue to explore the ramifications of the automobile industry bankruptcies. Back in May, the full Judiciary Committee heard testimony from a wide spectrum of viewpoints, most of which to some degree took issue with the plans of the Presidential Task Force for the Auto Industry for restructuring Chrysler and General Motors. Today is the opportunity for the task force to answer critics of its plan. One issue that has raised considerable concern with members of Congress on both sides of the aisle is the treatment of automobile dealers in the Chrysler and GM bankruptcy processes. As part of its structure, there were 789 dealerships that were eliminated by Chrysler, giving affected dealers less than a month's notice. Similarly, General Motors plans to wind down and then close 2,500 of its 6,300 dealerships, representing 40% of its dealerships. That's a lot of jobs in our communities and in America. The affected auto dealers contend their stores are not a cost to either General Motors or Chrysler. The dealers assert that GM and Chrysler benefit from having more dealers, not fewer. The car dealers also contend that GM and Chrysler selected dealerships for termination by using an arbitrary selection process. I'm particularly concerned about the impact these have on minority dealers, who I fear will suffer disproportionately. In my district, Mr. John Roy, the owner of a Chrysler dealership in South Haven, Mississippi, but a resident of my district, was the only African-American Chrysler dealer within a 300-mile radius around Memphis. He sold cars not only in Tennessee, but in Missouri, Arkansas, and Mississippi. Over many years, he built a reputation for high-quality customer service. He is one of only 2 Chrysler dealers in the Memphis area to receive an elite 5-star rating for customer satisfaction with Chrysler. He was also number 1 in sales in the Memphis metropolitan area for Chrysler. Notwithstanding all of those facts and his outstanding business acumen, his dedication and outstanding performance over the years as a loyal Chrysler dealer, Chrysler decided to terminate his franchise. To me, it is unconscionable that Chrysler would treat a successful and loyal dealer in such a manner. While I understand the task force had no role in selecting particular dealerships for closure, I'd like to know to what extent the task force considered the impact of widespread dealership closures on the economy and on communities around the nation and on the minority community that have been held back for so many years in this industry as well as others, but this industry especially. Another issue of some concern to members is the treatment of those with tort claims against the old Chrysler and General Motors. Totally new system. Central to the reorganizations of Chrysler and GM was the sale of their viable assets to newly created entities pursuant to Section 363 of the Bankruptcy Code. These new entities become the new Chrysler and General Motors. The sales were free and clear of liabilities, including claims of accident victims, victims of defective products, and present asbestos claims. The end result is the tort victims can recover little or nothing for their injuries because they can only assert their claims against the limited assets of the old GM and the old Chrysler, which is negligible. I'd like to know the task force plans for ensuring that tort victims receive just compensation for their injuries, which they should and have in other particular situations like this. I thank Mr. Bloom for appearing before the subcommittee today, and I hope this testimony will be enlightening. I'm sure it will be. I now recognize my colleague, Mr. Franks, that